Welcome to the Mansfield Podcast, your guide to U.S.-Asia policy. I'm your host, Tim White, and on behalf of the Maureen and Mike Mansfield Foundation, thank you for joining us. This season, we will be speaking with a dozen experts, academics, and practitioners in the field of Japan studies. We'll be looking at their work, as well as the professional experiences that have shaped their career paths. These individuals all participated in the 5th cohort of the U.S.-Japan Network for the Future program here at Mansfield. Today, we're joined by Tim Webster, Professor of Law at Western New England University. Professor Webster is also a lawyer and previously practiced international dispute resolution in Tokyo and New York. His research interests include the intersection of international law and the domestic legal systems of East Asian nations, including Japan and China. Most recently, he's been examining current movements on World War II reparations. Thanks for joining us on the podcast, Tim. We want to just kind of start off by asking you to briefly introduce the work that you get into, what you're working on now.
Sure. My research looks at Japan and East Asia's war redress movement. This is a number of civil society organizations, lawyers, activists, and some of the survivors themselves who have been looking for compensation or some kind of redress from the Japanese government and from Japanese companies over the past 30 or so years. This has taken on new salience over the past month as this forced labor issue, one of many, attracts a significant amount of attention in international press and the United Nations and other fora such as that.
Yeah, so this is a very complicated issue that we're going to dive into a little bit more as the podcast goes on. But to step back just briefly to see, the angle that you're coming at this from, many of the experts who've been involved in Mansfield programs are from the social sciences, from, they're historians, they're sociologists. You're coming at this from a legal background. So can you just talk about both how you came across this issue, your study in law, the fact that you are not strictly a Japan expert, you're a scholar across all of Asia?
Sure. So my introduction to this issue came as a lawyer. I didn't work on the case itself. I worked at a law firm called Morrison Foerster, which has a large presence in Japan and East Asia more generally. And Morrison Foerster was defense counsel for one of these forced labor lawsuits that was brought in California in 2002, 2003. I joined the firm in 2005, so I wasn't actually part of it. But part of the deal I made to myself was that if I went and practiced law at this law firm and took on these issues, I want to make sure that I wrote about them and I really immersed myself in them. And that's sort of what I've been doing for the past 20 years, is trying to understand the Japanese perspective, the Korean perspective, the Chinese perspective, the Taiwanese perspective, the Filipino perspective to the extent I can. And as you so kindly pointed out, I started off in Chinese studies and then did several years of Japanese and a couple years of Korean.
And so we often ask people, what first got them interested in Japan. In your case, it's more what first got you interested in Asia that led you down the path into this particular issue with Japan. But, what was it about China, if that's where you got your start, that first drew you in?
So going all the way back to high school, I took a religion class and I was positive that I would hate it because I thought they were going to be forcing some kind of Catholic or Episcopalian doctrine down my throat. And to my great surprise and to my delight, and here I am, 30 years later, still talking about it, we looked at some Taoist texts, we looked at some Buddhist texts, and that was really my entree. And that's really what got me excited about China, and we did some Zen texts as well, so I got kind of a Japanese perspective on it as well. But it was that way of approaching the world, that way of understanding that from Buddhism, life is suffering, but we are the causes of our own suffering. That still resonates with me now. There's a Taoist theme to all of this, which basically says, I don't want to say nothing matters, right? It's not nihilism, but if there's really a problem here, it's in large part because you or the people involved have their own mental blocks or their own perspective on it, and that maybe is what is causing the problem. So that I found very liberatory. And again, I'm always eager and looking for ways, including thanks to the Mansfield, to return to Asia in any capacity that I can.
And before we delve into the issue areas a little bit more, I wanted to get your thoughts on how you moved from this background working for a law firm, getting your training as a lawyer, into the world of academia. Of course, you're still
Hmm.
focused on law, but can you talk a little bit about that career adjustment?
So I think my dad is a lawyer, and one piece of advice he gave to me was don't go to law school and don't become a lawyer. And he said that because I think my dad has an understanding of what a lawyer is, and my dad, maybe to his credit and maybe not, worked extraordinarily hard. I rarely saw the man. He was out of the house by 5:30 in the morning. He would come home 6:30 at night, usually pretty exhausted. And so I think I probably also absorbed the idea that maybe being a lawyer is not what I'm cut out to do. But I did enjoy the study of law. I did enjoy, to an extent, the practice of law. But I've always considered myself more of an Asianist than a lawyer or an Asianist, as opposed to anything else. And so that was always going to be the focus of whatever career I did. I was in a PhD program in literature for a few years, and then ended up not loving that, and decided that, law seems to be relatively unpopulated. There are a few people who have the language background to really make a deeper, some people do, but it's relatively rare in the field of law that people have those language skills. And so I said, well, maybe law is where it's at, understanding that I was probably not going to be a lawyer or not be a lawyer for a long period of time. And sure enough, I practiced law for just a couple of years, and then was lucky to get an academic posting at Yale Law School at one of their institutions called the China Law Center, which is, as you can tell from the title, focused on Chinese law and Chinese legal reform. And that was sort of the pivot point between the professional career and the academic trajectory.
So to get into this topic, can you help our listeners kind of understand the context? I mean, many folks are familiar with the history, but some may not be. So I'm afraid we're going to have to go pretty far back to the origins of the Imperial Japanese presence in East Asia. So can you start to lay that groundwork for our listeners?
Sure. So, like many other world powers in the late 19th and early 20th century, Japan decided that colonialism was something that was strong enough to do. And as it looked, as Japan sought to enter the modern Euro-American league, for lack of a better term, colonialism was something that the United States was engaged in, France, Spain, Italy to a limited extent, Portugal, Germany. And I think Japan, as a country that aspired to be part of these, global leaders, for lack of a better term, decided that it too would need to exercise some kind of colonial or some kind of imperial power. The Sino-Japanese War, the Russo-Japanese War, showed to the rest of the world that Japan was a modern and military power. But law was also an important part of that, right? And the other countries that had been taken advantage of, and China, it would of course be the main example of that, retain their own legal system, right? And Western powers, United States, European powers, and so forth, looked at that and said, well, China's not really part of the civilized world. And the reason China's not part of the and I'm using quotation marks just so people on the podcast are
Sure.
wondering what I'm saying here. They weren't, China was not part of, and Japan became part of the civilized world because Japan in particular adopted a legal code, or as the case may be, a series of legal codes that resembled what the French had, what the Germans had, and then that's sort of Meiji. Later on into the early 20th century, Japan also becomes an imperial power, right? And trying to export its own legal system and its own material and military power, and using that to first take Taiwan in 1895, annex, again, quote unquote, Korea in 1910, and other parts of East Asia later in the 20th century, right? And so these, during the war period, serve as areas or resources, right? Human resources that Japan can call on for soldiers, for comfort women, for forced labor, for a whole bunch of different resources one needs to wage a war. And of course, Japan also relied on people living in Japan. It wasn't solely a colonial enterprise, but once Japanese soldiers or Japanese labor dried up, Japan then turned to Korea and turned to Taiwan primarily as sources for some of the human resources necessary to conduct a war.
Yeah. So, this led to, I guess what you would say, a pretty widespread use of laborers from around the region during that imperial era, and particularly during the wartime effort. When did this start becoming a legal problem for Japan and for the region?
So I think the movement, as I see it, really takes off in the early 1990s. There are a couple of lawsuits, and again, I'm looking at this primarily from a legal angle, so I'm most interested in litigation. And there are a handful of lawsuits brought in the 1970s, right? So I would, if we want to go back to this idea of war redress, or what I call transnational war redress, right? There's plenty of people in Japan who have asked Japan to compensate them for injuries they suffered. But I'm looking at it from a transnational perspective, meaning people from Taiwan going to Japan, people from China going to Japan, people from Korea going to Japan, and seeking redress in one forum or another. That could be through lobbying the legislature, members of the Diet, or using the courts to press their claims to redress. So there are, again, a handful of cases from the 70s, but it's not really until the end of the Cold War, the democratization process in Taiwan, the democratization process in South Korea, and I think a broader respect for human rights in those countries, China as well, and people reflect on, or maybe reconsider the effects of the war in the late 1980s. There are also movements in Europe, right? Polish people, Albanians, asking for redress from Germany, and some of those ideas filter over into China and into East Asia, and people say, hey, if the Albanians are doing it, if the Polish are doing it, maybe we can do the same thing vis-a-vis the Japanese, right? So it's with and again, the other way to answer that question is a lot of these issues had not been discussed publicly, right? The comfort women issue in particular is one that had been largely suppressed for decades. The forced labor issue as well. Maybe there's some public recognition of it, but it's fairly limited. And it's with the stepping forward of a handful of comfort women in Korea, and then in Philippines, and then China, and ultimately Taiwan, and so forth, as well as a handful of forced laborers who say, oh, this actually happened to us as well. So there's also, and one of the important dynamics here is the kind of social movement aspect to it as well. This is something that, again, I focus on the litigation, but it's when this issue takes off in the early 1990s, people are coming forward and saying, yes, this happened to me. Others in the region saying, oh, yes, that happened to me as well. Then you get the awareness of it. And then an important part of the story that I want to make sure gets due credit is that this is not just an issue of Korea versus Japan or Taiwan versus Japan. Maybe that's how it's presented in the media, and maybe that's a nice shorthand for it. But what I always like to call attention to are the people in Japan who are trying to make this happen, right? There's a strong culture of pacifism in Japan. There's a strong culture of Sengo Sekirin, this idea of war responsibility that's been in Japan, at least in the academic discourse, for decades. And so a lot of the people who are most active in this space are Japanese lawyers, Japanese scholars, and activists who think that the war was a mistake. I know that might not be a commonly or widely shared belief, but there are many people in Japan who would think that.
So I know that it's beyond just the bilateral contests that have come about in these legal cases, but when you look specifically at the Korea cases being brought against Japanese corporations, the common refrain from the powers in control in Tokyo is that all of these issues were settled with the 1965 normalization of ties between the two countries. Japan gave approximately $800 million in aid and loans to the Korean government at the time. And with that, it considers the issue legally settled. You've just laid out that the legal and social movements on these issues didn't begin until, in some cases, decades after that 1965 agreement. Can you talk about why that might be and whether there are parallels to that situation in other parts of the world where you have what one side considers a legally binding final resolution to this problem, and then it's decades later when the people are finally starting to talk openly about the problems?
Great questions. So I think there are many ways to respond to that. I think one maybe easy way to respond to that is to say that if we think about the Holocaust, for example, I would ask my parents about that, and they would say, "Oh, we didn't really talk about that until the 70s or the 80s." And I think a similar dynamic is present here. The war happened. Eventually there was the San Francisco Peace Treaty. There are restorative efforts, the Marshall Plan, for example, in Europe, and maybe not an accounting of the harm that is actually done. And I think that happened in Europe, and I think that happened in Asia. This move to forget the past, I think, with regard to the United States in particular, you have fears about the spread of communism, right? So rather than worrying about Nazis and fascism, which is the 40s concern, once Soviet Union emerges along with the United States as the victors, then the U.S. concern shifts from containing fascism or defeating fascism to containing communism, right? And I think with U.S.-Japan relations in particular, right, we go from being the ally of China, the nationalist, the Kuomintang in the 40s, to pivoting away from China and really placing a lot of our emphasis or a lot of our resources on democratizing and having a solid relationship with Japan, right? Because we're concerned that China falls in 1949, quote unquote, and there's a concern that in other parts of Eastern Europe, for example, communism is going to spread, and that's going to prevent and challenge American hegemony or the American way of life. So I think that's one of the historical answers. In terms of how it resuscitates in the 80s and 90s, I mentioned briefly the democratization movements in Taiwan, right? So for the 40 or so years after the civil war in China and Taiwan, you are led by a one-party state, Chiang Kai-shek and his son Jiang Jingguo. So that's not a very open environment for people to explore their history. Korea or South Korea in particular is very similar, right? You have a one party, you have various dictators over the course of those 40 years. And with these democratization movements in Taiwan and South Korea, you have a revisiting and a reconsideration of the past, including the war and the colonial period. And so people are rethinking these issues for sometimes for the first time, or scholars are turning their attention to it sometimes for the first time. China obviously is not a democracy, but I think even people who look at social history in China in the 80s and 90s, it may not be a democratization in the sense of China becomes a full liberal democracy, but there is more rights awareness. There is more attempts to vindicate rights, to consider rights, to think about rights than there were certainly in the 50s and 60s and 70s, right? So I think across the region, whether you get full-bore democracy as you do in Taiwan or South Korea, or a lowercase l liberalization as you get in China, this new space for scholarly reflection, for civil society organization, takes place in the late 80s and early 90s, and that also helps feed some of this war redress movement that I've been so focused on.
Right. So this brings us to kind of the current policy implications of this issue that you've been working on for your career. It's pretty clear to those of us who watch Asia closely that these issues, even though they date back 70 or more years, have real implications for the ability of these regional powers that agree on so many things to work together to advance the common interest that they do share. And particularly from the American perspective, with our two most important allies in the region, in Japan and the Republic of Korea, having still a high degree of mistrust or at least unease in working together. It's a major area of interest for Americans and the American government to see these countries working together more closely, and the historical issues have been the major impediment to that. So you have called our attention to some very recent discussions between the foreign ministries of Japan and Korea just last month, and some of the ways that they have been trying to talk this issue out. Can you summarize what's been going on there?
Sure. So again, the narrow issue here is about the issue of forced labor, right? Mm-hmm. There are other issues that we can dive into, but that's the kind of the current sticking point. And again, this is something that has been litigated for decades, first in Japan, later in South Korea. And when the South Korean Supreme Court hands down these two verdicts in 2018, holding these two Japanese companies liable, that's sort of the beginning of this fraying or degrading of South Korea-Japan relations. Now, South Korea-Japan relations are always a little bit fraught, but I think people have seen a thinning or an attenuation or a degradation of those relations quite precipitously over the past 2 or 3 years. And maybe we're now moving towards rapprochement, although again, I'm not sure that the Korean forced laborers themselves are satisfied with the current discussions. But the current thinking is, well, the Japanese companies deny liability. They have said, and they've said this fairly consistently, that they're not going to apologize. What they did during the war was perfectly legal. They did it with the support of the Japanese government. And they are not going to pay any compensation, including the enforcement of the judgment from 2018, right? So these 2018 decisions say Mitsubishi and Nippon Steel have to pay these Korean forced laborers, X tens of thousands of dollars. And in both instances, the companies have said, no, we will not. And so you then have additional litigation to enforce those judgments, right? So the Korean forced laborers now have these judgments that say you were owed X amount of money. And the Japanese companies said, well, we're not paying them. So then they had to file another lawsuit demanding the enforcement and recognition of those judgments. And those two have gone from trial to appellate, and now they're sitting at the Supreme Court. And the Supreme Court of South Korea has essentially stopped or sort of holding abiding its time, saying we'd like to see a diplomatic resolution to this. And I think trying to put pressure on the Korean government and the Japanese government to come up with a solution that is politically palatable and also satisfactory to the Korean forced laborers. The most recent news that I've seen of this came from January, and you had just adverted to it, and that seems to be the creation of a public foundation in Korea, paid for by the Korean government and perhaps paid for by Korean corporations, some of whom benefited from those grants and loans that were handed over from Japan to South Korea in 1965 that you talked about at the beginning of our conversation today. The problem with that, though, is that I think the forced laborers themselves, right, the Korean plaintiffs, and many of them have passed, so now it's their children who are standing in their place. They have suggested that what they really want is an apology, and they want an acknowledgement of the harm that they suffered, right? And there's been again, there's lots of lawsuits that have said what took place there, right? What these Japanese companies did to Korean forced laborers was itself illegal, right? You have Japanese courts saying that, and there are lots of different precedents we could talk about. You have Korean courts saying the same thing. So that, I think, lends some weight to these claims that maybe there should be some kind of compensation. Now, Japanese companies, again, as we said, have denied that this was illegal, have said, well, again, we can't call this forced labor, or they've said, this labor came from Japanese legislation, came from the National Mobilization Act of 1937, 1938, and we just did what we were told, right? So despite the dozens of lawsuits that have been filed over the past 25 or 30 years, Japanese companies have consistently held, well, we're not liable. We were just doing what we were told to do, and sort of deflect any kind of acknowledgement of harm through that particular move. So when we talk about what's going on right now, this idea, what seems to be the leading idea, is that Korea will create a fund that will pay compensation to these few remaining nonagenarians. But the Korean response to that is, that's not going to satisfy us, right? We're not really concerned about getting $80,000 at this point in our life. What we want is an acknowledgement of the harm and an apology that what happened to us was illegal, and what happened to us was a violation of our civil rights. That seems to be, in my opinion, what most of the forced laborers themselves are most interested in and most desirous of. Yeah, I mean, money's nice, but I think what galls them at this point in 2023 isn't the fact that they were never paid for it, but rather that there is an unacknowledged harm that they've suffered that continues to be pushed aside, or continues to be debated, or continues to be suppressed.
Right. So you've drawn our attention to two pieces that you've written in the last year or so that we'll have links to in the description on this podcast. One is an analysis you did for the Harvard International Law Journal that looked at transnational war reparations in Japan empirically, and there are some really fascinating conclusions and things that you've teased out in that I think our listeners would be interested in. But what I want to talk to you a little bit more about is the piece that you did for the United States Institute of Peace, the formula to resolve the South Korea-Japan wartime forced labor issue, where you start talking about this compensation redress mechanism. And of course, the last few months have seen the monkey wrenches that you've just now highlighted, the fact that the current discussion doesn't include apologies, would not include mandatory money from these Japanese corporations. So can you talk a little bit about where you see any ability to move forward on this issue?
Sure. Thank you. I want to point out that, yes, this is something that I wrote for the U.S. Institute of Peace, but the suggestions I have come forward do not originate with me at all. Right. What I have done is actually gone back and looked at a number of settlement agreements between Japanese companies and Korean forced laborers on the one hand, Japanese companies and Chinese forced laborers on the other hand, and said, if we travel back in time and look at what these different settlement agreements, again, brought about from litigation filed in Japan, what has happened before, maybe that can serve as a guide to this current dispute, right? So my takeaway from reviewing those settlement agreements is to say that yes, the money is a part, maybe it's an essential part of all of those settlement agreements. But in my opinion, the more important piece is an apology, right? And again, the wording of that apology, as it always is going to be scrutinized and debated, and it's going to dissatisfy a number of people. And again, every time Japan apologizes in Japan, Japanese leaders have apologized a number of times, right? It's important to say that as well. There's always somebody in South Korea or somebody in China who's not satisfied by it, or didn't go far enough, or whatever it may be. So I don't want to suggest that apology, you just say, I'm sorry, and that's the end of it. But I think that is probably more important, right? An apology that seems heartfelt, that seems to acknowledge the harm that was done, that would go, in my opinion, a much longer way towards reconciliation than just cutting a check for $80,000, right? Which is essentially what the Supreme Court of South Korea ordered these two companies to do. So I think if the long-term goal is lasting reconciliation or lasting rapprochement, that that apology is probably a more effective way of achieving that goal. The other part that I think is important is commemoration, right? So if you go back and look at these settlement agreements with Korean forced laborers in the 1990s and moving forward to the settlement agreements with Chinese forced laborers in the 2000s and 2010s, there is a lot of attention directed at how do we commemorate this, right? And that process of commemoration has different forms, right? You could have some kind of memorial service, right? So sometimes in the 1990s, Korean families wanted the remains of their departed loved ones repatriated, and Japanese companies were actually willing to do that. They said, yes, we will have a commemoration ceremony. We will pay for the Korean families to come to Japan, and we'll have some kind of ceremony which helps set their loved one's soul at ease. And that's something that Japanese companies themselves decided was an appropriate response, right? So you could have a service. The other sort of main form of commemoration is some kind of monument, right? And again, those come in different shapes and sizes and different designs and so forth. But the idea that there is a public statue or cenotaph, stele, something like that acknowledges this part of history, and it can't be denied and it can't be swept under the rug. It's there. It's physically present. That too seems to be a common element of these settlement agreements. So I think the commemorative aspect is important, and that can take the form of a service, or that could take the form of something more concrete than that. But that also, I think, needs to play a role. And again, I don't want to be viewed as the American interloper. I'm drawing that based on precedents from settlement agreements that Japanese lawyers and Korean plaintiffs, or Japanese lawyers and Chinese plaintiffs, worked out over the past 25 years.
Okay. Yeah, I think that's an important piece to highlight. Not to denigrate any work that you have done in synthesizing and analyzing all of these pieces, but that these ideas have precedence, in many cases precedence coming from the countries in question. You've talked briefly before about the specific categories of victims and survivors of wartime, and the broader context of war redress in general. Is there anything you want to say on those topics before we move on to the pieces about the Network for the Future program? Really?
Sure. So the other the longer article that you mentioned earlier, I try to, again, synthesize, track down as many cases that would fall under this transnational war redress litigation framework as I could find, and analyze the results, at least analyze the results from Japanese courts. And what I found there, and again, what I think is particularly important for an American audience, is that the cases most likely to succeed involved actually hibakusha, right? These people who had been irradiated by the bombing in Hiroshima or Nagasaki. So Koreans or Brazilians or Americans who were there in August 1945, and then in the case of Korea, moved back to Korea after the war, or moved to Japan, or moved to Brazil. Those are actually the plaintiffs that win their cases the most frequently, right? And again, those are cases brought by hibakusha against the Japanese government, right? So yes, even though the Japanese government didn't bomb Japan, obviously, the post-war legislation has created mechanisms by which hibakusha, the irradiated, can seek compensation or seek medical benefits at the expense of the Japanese government. And those are the cases that are successful the most frequently. Second most frequent successes are the forced laborers, right? Which suggests that there's at least some sympathy or some understanding that these cases have a legal leg to stand on. Mm-hmm. Other cases, comfort women, soldiers, POWs, things like that, those have been far less successful, which I interpret as, the Japanese judiciary doesn't think those are worthwhile, or doesn't think that those plaintiffs have a leg to stand on. But I think it is important, particularly because, as I mentioned earlier, Americans don't always have a great sense of our own war crimes, right? And
Mm-hmm.
that's also, I think, is an important part of the discussion, that we too, the United States, has also committed war crimes, and maybe you didn't read about them in your high school history textbooks, but maybe you should.
Right. Well, so we of course had the honor of having you participate in cohort 5 of our U.S.-Japan Network for the Future program. It was intended to be a 2-year program that lengthened due to the pandemic. But one of the things that we like to ask is, how can you reflect on that network experience? What did you glean from being brought together with other experts on Japan and having the opportunity to study the policymaking process in both of our countries?
Sure. Yeah, it's been really eye-opening, and I thank you, and I thank the other members of the Mansfield Foundation who have made this a reality for me. As we started, or as we said at the beginning, I'm a law scholar, and there are very, very few law scholars in the United States who work on Japan. And so I'm used to sort of existing in my own little bubble, and it's what I've chosen to do. I'm happy to do it. So the chance to engage with people of my age group, with my background, who are actively engaged in Japanese studies, has been really wonderful for connection purposes, for seeing what people outside of the law field are working on, bounce ideas off, to even to work on common projects. So I'll be speaking next month at AAS with a couple of members of the network. So that's been really intellectually rewarding and enriching, and maybe I feel a little bit less isolated than I might otherwise have done. Most people who work on Japanese law in the United States are 60 or over, right? And so it's nice to have a cohort of people who are roughly my age, who are all working on Japan or some aspect of the U.S.-Japan alliance. The second thing I would say is the high-level contacts that Mansfield has brought to the table. So, future projects, things like gay rights, things like the military, the U.S. military, U.S.-Japan military alliance, things that I don't really have much of a background in, have also been really helpful to me to say, aha, U.S.-Japan relations actually refers to 90 different things, or moves in so many different directions. And I think each of us in the academy, we have to, right? If we're going to succeed here, we have to focus on our narrow issue, right? So I'm only going to write about war reparations, to the exclusion of all the other fascinating components of U.S.-Japan relations, and for that matter, Japan-Asia relations, right? That's also an important piece. And I'm looking at this tiny little, thread of it called war reparations, but there's trade relations, there's diplomatic relations, there are environmental components of this relationship, and I'm grateful to have both the network members to help sort of thicken my understanding, but also to have access to people, the high-level people that Mansfield brings, either in DC or in Tokyo or in Seoul, or any of the other area, Montana for that matter, where the Mansfield Foundation is able to bring people in to show us, you think U.S.-Japan relations, but what is, orange, but there's an entire spectrum out there that you are completely unaware of. So that's also been a really rewarding part of this experience for me.
I like that metaphor, and I think that's a great segue to say that we delve into some of those other colors in the spectrum in other episodes of this podcast, hearing from other members of the Network for Future, and I encourage our listeners to take a listen to those. One of the final pieces that we always end with is asking people to recommend one book in this field to somebody who wants to get into this topic a little bit more, who may not have an advanced law degree on these issues. Of course, we're going to direct people to the work that you've highlighted for us, but is there anything else that you would direct people to for additional reading?
When I think about U.S.-Japan relations, I think of John Dower, he's a historian. I think you could look at anything that guy has written and learn a lot from it. Ways of forgetting, ways of remembering comes most immediately to mind. But yes. John Dower is, an eminent U.S. historian of Japan, but he is able to write about race relations and military history and diplomatic history, and always able to generate interesting and novel insights. And he writes beautifully. So, if you're, and he's actually, you could probably find him at Barnes and Noble. He's one of the few Japan studies people who has a popular audience, and whose work would be available at not the academic bookstore, but at the Barnes and Noble, your local used bookstore. Anything John Dower writes, I think, always offers a wellspring of insights into the U.S.-Japan relationship.
Yeah, and of course his Embracing Defeat won the Pulitzer Prize, which helped elevate it into that kind of mainstream bookstore type of book. But Ways of Remembering is definitely a good entry point to the topics that we've been discussing today. So with that, I want to thank you, Tim Webster, once again for taking the time to speak with us. And I hope you've enjoyed this conversation as much as I have, and I'm sure our listeners will have gleaned quite a bit from this conversation. Thanks, Tim. We hope you've enjoyed the conversation with Professor Webster. More information about his work, including a link to the article discussed in this podcast, is available in the description. Join us next time for a discussion on gender equality in Japan's society and workplaces with Dr. Hilary Holbrow. This season of the Mansfield Podcast is made possible with support from the Japan Foundation. Special thanks to Nick Velez for editing. Music is courtesy of Laura Schwartz and Bellwether Bayou. Thank you.
The sermon he sold.